Hello, good morning, good afternoon, or good evening, whenever you are, and welcome to the FIFA Law Talks 2021. It's a great pleasure to introduce this new activity, the FIFA Football Law Talks, that it is tailored towards in-house legal counsels of national or international federations, clubs, leagues, player unions, and lawyers with an interest in sports law. The different presentations that we have planned over the next 6 months will be delivered by experts and practitioners from specific legal fields. The FIFA Football Law Talks will bring together football law professionals from around the world and provide for a presentation, comprehensive discussion, and Q&A sessions. Each session will be streamed on FIFA.com with simultaneous interpreting into Spanish and French. During the presentation, you will have the possibility to ask questions to the guest speakers. If you want to do that, please use the Q&A functionality of the Zoom application. The question will be answered by the guest speaker after the presentation. Si quieres continuar en español, por favor selecciona el botón de interpretación en esta ventana de Zoom, más abajo, esta concreta opción. Pour continuer en français, cliquez sur le bouton d'interprétation en bas de cette fenêtre de Zoom pour avoir accès à ces options. Today is the first session of the program, which will be focused on the analysis of the new World Anti-Doping Code. The World Anti-Doping Code is the core document that harmonizes anti-doping policies, rules, and regulations within sport organizations and among public authorities around the world. The code works in conjunction with 8 international standards, which aim to foster consistency among anti-doping organizations in various areas. The revision process for the 2021 code began at the end of 2017, and following 3 phases of consultation over a 2-year period, with over 2,000 comments received, the revised code was unanimously approved on 7th November 2019 at the World Conference on Doping in Sport in Katowice, Poland. On 1st January 2021, the new World Anti-Doping Code came into force. The 2021 World Anti-Doping Code has just brought us several amendments which will change important aspects in the fight against anti-doping. From the new provisions concerning substance abuse to the greater flexibility in relation to sanctions or the new requirements related to the independence and transparency during the disciplinary proceedings within international federations, the code contains relevant new provisions which deserve a proper analysis. And there is no better than the WADA legal director, my colleague and friend, Julien Sieveking, to introduce the new code. Julien, good morning in Montreal. Good afternoon from Zurich. Thanks for being with us today. Hola, Julien, ¿cómo ça va?
Muy bien, très bien, merci beaucoup. It's a pleasure to be here. Thank you for the invitation, Emilio. Always a pleasure to speak about our core documents and to provide additional knowledge about the anti-doping system. So it's a pleasure for me to be with you today.
Julien, I said enough, so the floor is yours. And again, on behalf of FIFA, thank you very much for this presentation. The floor is yours.
Thank you, Emilio. So I will start to say hello again, wherever you are. I hope you're having a great time, despite the complicated period we're going through. So obviously today I'm going to speak about the World Anti-Doping Code. Some wrongfully call it the WADA code. It is not. As Emiliano mentioned, it was drafted following a consultation process with all stakeholders. So it's not the WADA code, it's really the World Anti-Doping Code. It's a fundamental and universal set of rules. Since 2004, it's harmonizing anti-doping rules all over the world for almost 20 years, therefore now. So the objective is to ensure that all athletes are treated the same way when committing the same offense, that their cases are adjudicated timely and in a fair manner, whatever the sport or country is. Um, the code is not self-applicable. The code has to be implemented in the rules of the signatories. We have to date 691 signatories to the code. These signatories are MEO, which are major event organization, obviously also international federations such as FIFA, National Anti-Doping Organization, and also National Olympic Committee, National Paralympic Committee. So a wide range of category, and as I said, almost 700 signatories for now. So the code rules are not directly applicable. The code is a document which is a private set of rules that is established by a private organization. I remind you that WADA is registered as a foundation under the Swiss Civil Code. So the rules must therefore be implemented in the rules of the signatories. We can call it a kind of a contractual agreement. By signing the code, the signatories accept to be bound by its rules and to implement these rules in their sets of rules and to apply them. Obviously, these rules have to be implemented without material change to prevent undermining the harmonization across sports and countries, which is the objective number one of the code. Also, I would like to mention that the code is not applicable to governments. So it applies only to member sport organizations that I mentioned. So for government, there is the UNESCO International Convention Against Doping in Sport, which provides a legal framework under which government can address specific areas of doping that are outside the domain of sports movement. Two last important points on the code is that first, there is a compliance monitoring, because it's good to have compliant rules. It's good to have implemented the code rules in the anti-doping organization rules, but then the rules need to be properly applied. And this is a key aspect of WADA's work, is to ensure by compliance monitoring that all the anti-doping program conducted by code signatories are in compliance with the rules of the World Anti-Doping Code. Last but not least, the code has to respect, and particular attention had been paid to that by WADA since the very beginning. The code has to respect the principle of proportionality and human rights. So since the very first edition, we ensured that the code rule comply with this principle. In particular, for the 2015 and the 2021 World Anti-Doping Code, we have sought on key question the opinion of the former judge president of the European Court of Human Rights, Jean-Paul Costa, who both in 2015 and 2021, both time review the code and the questions submitted, and in order to ensure that our document and our set of rules was compliant with the human rights. Some changes had been made during the revision processes to ensure this compliance with the human right principle, and particular focus is placed on this principle, and it is mentioned in the introduction of the World Anti-Doping Code. The code is not alone in the anti-doping framework. We have already another set of rules. We have also other set of rules, what we call the international standards. The international standards are the documents that we can call the second level of the regulatory framework. They contain technical and operational rules for the implementation of the code principles. They do not need to, unlike the code, they do not need to be implemented directly in the rule of the signatories. They are directly applicable. And they are regularly revised when necessary, like the code, in consultation with the stakeholder to ensure they remain fit for purpose. So there are currently 8 international standards. The last 2 ones have been approved with the new code in Katowice. So they all cover very particular and specific technical areas. So you can see the list on the slide. So there are, the first one is the testing and investigation. So all rules concerning how to conduct an anti-doping test, how to plan testing, and also how to conduct an investigation. There is a standard on laboratories, which is also very important. As you know, due to the principle of strict liability, we need to ensure that any adverse analytical finding reported by a WADA accredited laboratory is based on an approved and duly reviewed method and analytical process. So everything is set forth in this standard. There is also a standard on what we call the therapeutic use exemptions. Very important standard, because most of the doping substances used by treats are medication, in fact, that are deviated from their original objective and used in doping, but also athletes obviously may also be face some sickness and have to take some medication. And if the medication that is needed to treat them contain a prohibited substance, they may ask for an exemption under certain condition to be able to use this medication. One of the key standards is obviously the list of prohibited substances. So this is a standard that is reviewed every year, but by an ad hoc group of experts to ensure that it's every time updated and fit for purpose and include all substance that may have a doping effect or that may fill out the other conditions set out in the code to be included in the list. Then we have two standards that are more recent, but also very important: the protection of privacy and personal information. We all know the importance of the data protection regulations. In anti-doping, we use a lot of confidential data from athletes. So particularly their whereabouts, we have their private address on Adams, their whereabouts, also their medical information, in particular in liaison with what I mentioned earlier, the therapeutic use exemption. So it's key that all anti-doping organizations use this data in a way that is compliant with with data protection regulations. Athletes need to trust the system, so an anti-doping organization need this data to do their work. So this standard is very important to ensure that all information with a confidential nature is treated appropriately by anti-doping organization. Another of the most recent standards is the code compliance for signatories. It was adopted in 2018. This standard fixed the process to be followed when non-compliances are reported in the anti-doping program by a signatory. You all heard recently of a CAS decision that made the headlines about non-compliance by an anti-doping organization. The process was based on this standard. And we have two new standards that were adopted during the code revision process, no, at the same time of the 2021 code, but that were developed during the code revision process. It's the result management standard. I will speak about this standard more in detail in my presentation, and as well as the education standard, education being obviously a key element of any anti-doping program. So now just the time to change my slide. Seems that I lost the connection. It's okay. So the code revision process. The code is a living document. It's something that is reviewed periodically. You can see that the first code was adopted in 2004, and there were already 3 revisions in 2009, 2015, and the latest one in 2021, which is the one I will speak about in more detail today. All this revision process lasts approximately 2 years and have several rounds of consultation with all stakeholders, not only the signatory. Anyone can comment during the code consultation. We have comment from lawyers, from students. So you don't need to be a code signatory to comment. We are reviewing all the comments, and this is always much appreciated because, as always, the objective is to ensure that the rules are understood and appreciated by all. And these revisions are really a must because the anti-doping tools evolve. For example, over the year, we have developed the athlete biological passport, but also the doping techniques evolve, the science evolve. So it's very important that the rules follow the evolution. So now let's see more in detail the revision process of 2021. My slide did not change. Yeah, okay. So the initial idea was that we did not need a full review, but more some fine tuning. There was no need to reinvent the wheel. And in the end, this is what happened. There were way more changes than what we expected at the beginning, but the key principles were kept in the code. There were no discussion about the key principle. For example, the condition for a substance to be included on the list, the 4-year standard sanction, or the principle of strict liability. All these standard, all these this principle were supported. It's also important to say that the consequence of that is that all the comments were much more focused on technical issues, and we received a lot of very good comments and of a complex nature also. But in general, the stakeholders' report was that the 2015 code, the previous code, has worked well. So we got very few feedback on major principle, but a lot of feedback on more detailed aspects. And as always, we had to make some choice, because it's always, people say the code is long, it's complex. So what do we do between, on one side, the complexity and the length, and the other side, the need for clarity and harmonization. Another point that I would like to highlight today is that most of the changes, if not all, were supported by athletes. We had, for the first time in the code who is now the current chair of WADA Athletes Committee. And it was very important to ensure that all the proposed changes were supported by athletes. So we had a regular contact with athletes group, whatever the WADA Athletes Committee, or also athletes syndicate during the code review process. And this code really is favorable to athletes, because we also put some more emphasis on the athletes' health. And as some of you may know, we also have developed the Athletes Anti-Doping Right Act, which is a document that compiles all the principal rights, the most important rights that athletes have in the anti-doping process in one single document. So as regards this code revision process, sorry, change the slide again. Okay. So it's, as Emilio said before, it started in 2017. It was approved in Katowice in 2019. There were 3 phases of consultation. The code drafting team reviewed all the comments received at each phase, discussed with many stakeholders. As you can see, we hold more than 100 meetings with stakeholders, and we also received more than 2,000 comments, so several hundreds pages that were duly analyzed, discussed, and when consensus exists, transposed into new rules. All of this was run under the supervision of the WADA Executive Committee, who had to accept each draft before being put in consultation in the following round. Also, as I mentioned, during this phase of consultation, it appears that 2 more new standards were required. So it was a demanding exercise, because at the same time, we had to develop 2 additional international standards on result management and education. So I will start now to discuss how this 2021 case code looked like. So I would like to start with the 3 topics that are for me of importance and reflect the need we had to adapt to our permanently evolving environment. The first one being the delegated third parties, because we have seen in the past that our stakeholders have been more and more delegating part of their anti-doping program. And there was some confusion under the previous code whether anti-doping organization could delegate aspects of their doping control process, and the extent, and about also the extent to which they remain responsible following this delegation. So the introduction of the code and Article 20 in this code now set forth the stakeholders' responsibility. So things are clear now. It's obvious that ADO are responsible for all aspects of the doping control, but that they may delegate any of those aspects to a third party. The fact being that they always remain fully responsible for the performance of their anti-doping program. They remain responsible as regards the compliance with the code. So we have added a broad definition of the term delegated third party in the code to clarify the stuff. But the most important thing is really that anti-doping organization can delegate part or the totality of the anti-doping program to third party, but they remain responsible. It was very important to clarify that. You have probably all heard about the newly created International Testing Agency, which is the ITA. Many international federations have now delegated parts of the totality of the anti-doping program to this organization. So this organization is a delegated third party, and even if they are the one conducted the program of an international federation, for example, in terms of compliance, the international federation remains responsible. I apologize, but I have some problem with changing the slide because it's disconnecting. Okay, another key aspect is the whistleblower protection, Article 211 of the code. It's important because it's a new anti-doping rule violation, the 11th violation set out in the code. I would say that the reason for that is investigations are now important. Many cases have now shown that it is important. Investigations are important, if not to say more important than doping control, to uncover doping practices. Investigations are often triggered by information provided in confidence to anti-doping organizations. So the people reporting this information needed to be protected. So this Article 211 that you have on your screen makes it an anti-doping rule violation when someone threatens another person in order to discourage that person from the good faith reporting to authorities of information relating to an anti-doping rule violation, non-compliance with the code, or other doping activity, or to retaliate against another person for doing so. So there is a specific range of sanction for that, which is 2 years to lifetime ineligibility. I would like to specify that this provision only protects whistleblowers insofar they revert to anti-doping organization to provide information to them. If on the contrary, a whistleblower turns to the public or the press, it would be difficult to enjoy the protection of the WADA code in case of threat of retaliation. However, in such circumstances, we hope that local statutory provisions on whistleblower process protection may come into play. But it was very important for us to have this rule in the code to provide an additional level of protection to whistleblower. The next topic I would like to address is the education. I already briefly mentioned that. Education is a very important aspect of any anti-doping program. And it had no standards. So now a new standard was developed and it has made a defined term in the code. So most of the detail that were before in the code were moved to this international standard for education. It's clearly a very important part. At the last symposium, at the last WADA symposium, which took place in 2019, the 2020 edition was obviously cancelled for the reason we know. But at the 2019 symposium, it was clear for our stakeholders, they made it clear that education should be the priority in anti-doping in the coming years. So I think that no one could say that education is not essential, whatever in anti-doping or in other topic. In anti-doping, we have to start with young athletes because it's very important that the first contact with anti-doping is not a doping control, but some education and training. So now education has a place it has to be. I don't want to enter into detail now, but it's a recognition now, and it will be also reviewed, included in the compliance monitoring to ensure that each anti-doping organization, each code signatory implement an appropriate anti-doping program to what relates to education. So now we will go to other topic, starting with result management. I will present now a few topics about this new code. It's impossible to present all the changes in 40 minutes, so there is obviously a subjective choice that I made on the topic to present today, but there is a question and answer session at the end of this presentation. So I encourage you to ask any question you want if there are topics that I did not cover and where you have some question. So result management, result management, there is a new definition, and so result management is the process encompassing the time frame between the notification through the charge until the final resolution of the matter, including the end of the hearing. This is where an appeal was lodged. So there is a new international standard. It was very important because with education, result management was one of the sole essential area of anti-doping that did not have a dedicated international standard. In addition, the rules on result management that were in the 2015 code in Article 7 were very detailed, very technical, and maybe too detailed and too technical to be in the code. So they have now been moved to this standard, this result management standard. But the important principle, particularly those which address relationships between stakeholders in result management, remain in the code. The key stuff that the key takeaway from this ISRM, we can say, of, for example, the timing to run a case, and it is said that cases should be closed within 6 months. There's also some novelty as regards the notification process, which is now a 2-step notification process, and also there are many rules now on the establishment of the pool of members for hearing panels, independence of hearing panels. So the question of hearing panels that I will discuss at my next slide is a very important aspect of result management and of this new standard. And obviously, now that it is a standard, it means that all this result management process will be duly monitored in terms of compliance. And it's very important because when an athlete is charged with an anti-doping rule violation, the due process, fair hearing, all these principles should be respected, and this will be monitored under the compliance angle. So as I was saying, hearing panels are part of the most important aspect of these 2021 rules, with a basic principle. As you know, there are 2 levels: the first instance panel, the first instance level of jurisdiction, and then the appeals body. So the rule is that for the first level of jurisdiction, the panel shall be operationally independent, and that in second instance, the appellate body must be institutionally independent. I will come back on this definition slightly later, but this is a very important clarification, because a number of stakeholders suggested that the fair hearing requirements that were in Article 8 in the code be expanded. So this concern about the impartiality and independence of the hearing panel was one of the topic that triggered most comment from the signatories. So there are now specific rules, and there are, even if the major principles are kept in the code, the detail are in the new international standard for result management. But both this question of operational independence and operational independence have been made defined terms under the anti-doping code, the World Anti-Doping Code. There are also further procedural protection that have been provided now. Obviously, the fair hearing, that the decision and the process are run and rendered within a reasonable time. All these details are in the ISRM. There have been also clarification that virtual hearings are explicitly permitted. And obviously, we did not know about COVID at this time, but it's particularly useful now. So it's now explicitly allowed to have virtual hearings to deal with anti-doping cases. The athlete also has been provided with the possibility to challenge the panel members in case an athlete may consider that one of the arbitrator or panel member in charge of his or her case is not independent, is not impartial enough. So the he has or she has the possibility to challenge that. Another important point is the possibility for the athlete to ask for a public hearing. Some of our stakeholders, in particular in Europe, were asking for mandatory public hearing, but the solution that was proposed, given that it's more to protect the athlete in case an athlete consider that the case may be dealt with in a biased fashion, to ask for the hearing being public. So it's not automatic, but the athlete can ask for his or her hearing to be public, and this is also an important change. So on next slide, I'll now come back to this definition of operational independence and institutional independence. Operational independence, I mean, if we take FIFA, for example, within FIFA, you have the FIFA disciplinary body. I think that's the name for the first instance. I'm looking if Emiliano confirm it's the right name, but it's a first instance panel that will deal with the anti-doping cases. So it can still be a FIFA panel, but it means that they have to be operationally independent. FIFA can appoint a member, but once they deal with the case, they have to deliberate and make their decision in an operationally independent way. So I'm not going to enter into all the detail, but you have this. You have the definition on the slide, and it's also in the code. And for institutional independence, so there it's for the appeals body, you need to have in the process a totally independent instance. It means there it cannot be the same organization. It has to be a totally different institution. So for international federation, if they have in first instance the disciplinary panel, but the second instance for international federation will be the Court of Arbitration for Sport. And this court is obviously institutionally independent from the international federation. This is what is important. So first instance, some operational criteria to ensure that the panel member can decide independently. And in second instance, ensure it's mandatory now that the appeals body is totally separated from the organization responsible for result management, in order to guarantee each athlete that his or her case has at one level a totally independent review from the anti-doping organization that brought the case forward. So this is a key principle, but it's now in the code and in the international standard for result management. Another important novelty, if I can say, is the possibility of what we call now result management agreement. We all know that to run anti-doping cases is costly. If you have to go to first instance and then to the CAS, it's even more costly. It takes time. And so, but not only for anti-doping organization, but also for obviously for athletes. So we try to find ways to shorten that in a way that's still guarantee still provide the necessary guarantees and the respect of the basic principle. One of them is this Article 10.8.2. So in case an athlete who is normally subject to a 4-year period of ineligibility, it can be agreed on a reduction. So there are several conditions, but if the athletes, the ADO, the anti-doping organization, and WADA enter into what we call a case resolution agreement, there could be an agreement of a reduced sanction. And if such an agreement is reached, then there is no need of hearing, and there is no possible review because there is no appeal, as it will be an agreement signed by WADA, by the athlete, and by the organization in charge of the case. So this will allow to have reduced sanction for an athlete, and will allow also for anti-doping organization to run the case faster and with less cost. We will see how it works in practice, but we are hoping that this will be helpful for all, both on the athletes and the anti-doping organization side. The 2021 code also offers some more flexibility on some questions. Sorry, I have to change the slide again. one of the first area where more flexibility is provided is what we call, oh, sorry, not connected for this. Okay, what we call recreational athletes and protected person. So let's come back a little bit. Currently, in the 2015 code that was in force until end of last year, there were some possibility and some flexibility in the rules as regards minors athletes. But we received comment on that because in particular from athletes, because some minors, for example, the age of when you are still a minor and when you're not a minor anymore can vary from one country to the other. But also at the request of athlete representative who sent many comments on that, elite 16 and 17 years old athletes are not included in the definition because they, considering their sport experience, they should receive the same treatment as other elite athletes. So there are some difference now between 16, 18, as you can see, and it's important because it's true that at 17 years old in some sports, you may have athletes that have such an experience, maybe even they are going to the second Olympic Games, and they should be treated the same way as athletes who are above 18, but that are competing with them. So now we have a category that include minor, but it's protected person. So as you have seen, it's an athlete or other natural person who at the time of the anti-doping rule violation, one, has not reached the age of 16 or has reached the age of 18, but is not in the registered testing pool, which normally comprises the highest level athlete in the sport, and has never competed in any international event in an open category. So that makes a distinction between minors now, depending on the experience, if I can say like that. And also a third part is included in this question of protected person, the person that lack legal capacity under applicable national legislation. So protected person, minors, and a person who lack legal capacity. And another category of we have created now where, and we'll see in the next slide, where more flexibility is provided, is what we call now the recreational athletes. Because under the current code, under the, I still already forget that we're already in 2021. So under the previous code, anti-doping organization were not required to test lower level athletes. They had to test national level athlete, international athlete, but athlete below that level, there was no requirement and no obligation to test them. But in case they tested them, and in case of positive test, they had to apply the same consequences as to any other athletes. And during the process, or review process, we have a number of stakeholders comment, and they said that, yeah, lower level athletes are tested. Even some are tested athletes, are testing people in school, in fitness center, and because they do that as a matter of public health, and they're imposing the full code consequences to persons that are not really high-level athletes was counterproductive. So we needed to find solutions to ensure that these lower level athletes who did not have the same anti-doping educational opportunities as higher level ones. And also, if we take into account the consequence of the mandatory public disclosure of the anti-doping rule violation and the consequences they might have, for example, on the employment status of someone who participates in the sports only at a recreational level, could be unduly harsh. So the new code definition described these lower level athletes as recreational athletes. The determination of what kind of athletes enter in this category is left to the national anti-doping organization of the country. But there are some limitations, as you can see in the slide, as regards who could enter in this category. So protected person and recreational athletes, the objective is to have more flexibility. So for example, if you are entering in one of these two categories, for example, you don't need to establish the source of the prohibited substance to be eligible for a sanction reduction. This is important because under the code, the first condition to benefit from any reduction of the standard period of eligibility is to explain how the prohibited substance came into your body. So this requirement now is not there anymore for protected person and recreational athlete. Also, if there is no significant fault, then the period of ineligibility can go from a reprimand to 2 years. So this is a lesser sanction scale than for other athletes. And another important point that I mentioned earlier is that you don't need to report publicly the sanction. And this is essential, as I mentioned, because if you are a low-level athlete taking part in some open competition here and there at recreational level, and you are tested positive, with mandatory public disclosure, it can have really harsh consequences on your employment, for example, on other aspects on your life when you are not a high-level athlete. The next point I wanted to address in terms of flexibility is what we call the substances of abuse. This is an important topic in the new code. No, my slide did not change. Here you go. So, oh, sorry, I went too far. Okay. So, substance of abuse, what is it? During the revision process, we received a considerable stakeholder feedback that sanction for street drugs, social drugs, substance of abuse, however you call them, remain a significant problem. In particular, cocaine, which use is unfortunately widespread. But the council stakeholder made the following point: the use of this drug is a problem for society in general, but is not related to sport performance. And the code only prohibited this use in competition, because if we take the case of cocaine, it's obviously still a very powerful doping agent, but we all know that it's now mainly used in a social context, and when it's used a few days before a competition, it has no effect on sport performance, but can still be detected in the athlete's sample. And when you're positive to a prohibited substance in competition, then you face a sanction. So in case where an athlete has an addiction problem, for example, and not a performance enhancement problem that affect the level of the playing field, the signatories should prioritize the athlete health. Because again, it was considered by the stakeholder that it's not the role of anti-doping to look at this addiction problem, but our role in anti-doping is to ensure that athletes compete at fair level without benefiting from the use of substances. So in addition, substantial resources are spent in defending this case before the hearing panels, and these monies could be better spent on other anti-doping matter. So the majority of the stakeholders advocated for a more flexible approach with respect to substance of abuse. So based on their input, there's a new article that provides as follows, two new articles. The WADA list expert group will identify those substances on the prohibited list, which are often abused in society outside the sport, and they will qualify these substances as substances of abuse. The list expert group was requested to do so. They did it, as you can see on the slide. We have now for 2021 the following substance considered substance of abuse: cocaine, and I won't read you the real scientific name, but ecstasy, heroin, and cannabis. So it means for these substances, if an athlete is tested positive in competition and can establish that the use was unrelated to sports performance and was not taken in relation to any competition, the sanction can be only 3 months. And if the athlete is going through a rehab program, the sanction can even be reduced to 1 month. So this is a major change, because now if an athlete is positive to cocaine, the minimum now under the previous code, sorry, the rule is an athlete is positive to cocaine or to MDMA, the minimum sanction is to be 1 year. So it's important now to differentiate the addiction use, the social use, to differentiate it from the doping use. Obviously, if an athlete tests positive for cocaine in competition at a particularly high level, is still a powerful doping agent, and this athlete is still facing the risk of having a 4-year ban. But if the condition I mentioned are met, the athletes can benefit from a much reduced sanction scale. Contaminated product, it's also something important for us, because if you look at the 2015 code, there is no change in the 2021 code as regards contaminated product. So it means if the athlete can establish that there is no significant fault or negligence and that the origin of the positive is a contaminated product. And what is a contaminated product? It's a product where the substance at stake is not disclosed on the label and where no information is available in a reasonable internet search. Then there is a reduced sanction scale. However, it became also clear that the ability of WADA accredited laboratory to detect minuscule quantities of the substance were causing problem. In some cases, this capability have improved 100 to 1,000 fold over the last decade. So it means laboratories are able to detect really low quantity in an athlete sample. So this increased analytical sensitivity has made it easier to detect the tail end of the excretion curve from an intentional use. However, it has also increased the likelihood that an adverse analytical finding may result from contamination of a supplement or other product. So the current code provides that in order for an athlete to receive a reduced sanction on account of product contamination, the athlete must be able to identify the contaminated product. But now the situation has changed because there are cases where the level is so low, involving a substance that is known to occur in contaminated product, but the athlete is not able to specifically identify the product which caused the finding. We need to find a solution. So it's a complex matter. So rather than modifying the rules, the current rules on contaminated product, we decided that a better approach was to create a specific working group that is working currently to find a good way to approach that. So the idea will be to introduce new thresholds for certain substances to avoid that very low level that could be the result of a contamination are prosecuted. And we will probably have a solution tabled at the next WADA Executive Committee meeting in May. So this is important. So this group is reviewing the risk of contaminants appearing in natural and unprocessed foods, assessing the risk associated with legitimate medicines based on real cases. We had recent cases like 5 or 6 in the past months where an athlete using an official and approved medication tested positive for another substance that was not listed on the label. And it means that this official medication, even official medication, could be contaminated with other substance. So we are looking at that. Obviously, an important question about contamination is meat contamination. You know that in certain countries, they use certain substances to grow cattle. It's the case of clenbuterol, for example, in Mexico. So now we have a specific rules for clenbuterol because it was admitted and established that in some countries this is used. But there are other countries and other products, and so we had many cases where athletes alleged that their positive came from the ingestion of meat, but it's not that easy. We have to see what is the product, if there are evidence, if there are research, if there are studies on that. But we're really looking at the issue because, again, the objective is not to sanction anyone whose only fault is to have consumed a legitimate foodstuff or product that was contaminated. But it's not an easy issue. Work is being conducted on this. And I will end my presentation after speaking of result management and increased flexibility on the question of the focus on independence, because I must say this is also consequences a bit of the Russian cases. So we strengthened the need of independence in the code. For national anti-doping organization, for example, we have a new article 25.1 that stipulates that no individual who's involved in the operational decisions or activities of a NADO may at the same time be involved in the management or operation of an international federation, national federation, or government department with responsibility for sports. And WADA recently published a guide to strengthen national anti-doping organization independence. You can find that on WADA website. Another area where the focus on independence was strengthened, it's for the laboratories. Now, the code article 20, which lists all the obligation of the signatory, we have added the mandatory requirement to respect the operational independence of the laboratories. Also in the standard for laboratories, the laboratory independence and impartiality is addressed now. They have to be administratively and operationally independent from any organization that could exert undue pressure on the lab and affect the execution of their task and operation. And also something important, we have added an obligation for all signatories that say that they have to ensure that their employee and official agree to be bound by the code, and also that signatories do not knowingly employ any person whose action could have violated the code. It's important to ensure also that people working in anti-doping, people working in sports, people working in sports organization, and responsible for doping control do also themselves behave in compliance with the code and can be sanctioned in case they don't. So, Emilio, I think time for me to come back to you.
Thank you very much, Julien, for the presentation. We all know that the anti-doping ecosystem and the anti-doping legal framework is not easy, but nevertheless, I think that you have provided us with a fantastic insight into the new amendments to the World Anti-Doping Code 2021. So congratulations. And again, thank you very much for this presentation. As we say in football, so much attendance today. We almost reached 400 participants. So 389, something like that, in various parts of the presentation. So obviously, thanks to you, not only the topic, also to you. So I think that is a very good figures for the first session of the FIFA Law Talks. So we have received several questions from different participants. So for sure, easy for you. Not for me. So, if you agree, we are going to select a couple, 3, 4 questions. So if you are ready, okay, good, excellent.
I am.
Excellent, good. The first one is, you said that the World Anti-Doping Code 2021 is not applicable directly and shall be implemented by signatories. What if they fail to do so? And are these situations in which the World Anti-Doping Code would be applied directly?
Okay. So I confirm the code cannot be applied directly. It's a set of rules established by WADA, a private organization. So it has to be implemented in the signatories rules. And by signing the code, the signatories accept to be bound by its rule and to implement the code in their rules. So if they don't do that, their athletes and their sport is not covered by rules in compliance with the code. But if they are signatory to the code and they don't implement the rules, obviously it's a compliance issue. And so the case would be reported to what we call the Compliance Review Committee of WADA that will address the matter based on the process set out in the code compliance standard. And this may trigger some sanction when a signatory is not compliant. Sanctions are varied, but it can, if a signatory is declared non-compliant, there could be several consequences that you can consult in the standard, and also in the code. These consequences are listed. Would the code apply directly and alone? Again, no, but there are parts of I mean, part of the code rules have to be implemented in the signatories rule because it's mostly the part that apply to athlete and to doping control. But for example, the Article 20, which is the responsibilities of obligation and responsibility of the signatories, for example, this article does not need to be reproduced verbatim in the anti-doping organization rules, but it still applies because it's part of the agreement signed by the anti-doping organization. So it does not need to be implemented in the rule, but it applies. But again, does not apply directly because if the organization has not signed the code, it's not a signatory. So for the code to apply, there is a need to be a signatory, and for several articles to be implemented in the rules of the organization.
Thank you very much, Julien. We have a second one. Could you please briefly explain the concept of good faith regarding whistleblowers?
Okay, but I mean, if we take this new article 2.11, where we speak about good faith, is that we protect the people. This article make it an anti-doping rule violation if you try to retaliate or to intimidate the person willing to report or having reported a potential anti-doping violation. But obviously, if you report that it is not in good faith, it does not apply to you. We can imagine cases that people report violations that are not real, or that report violation just to bother a competitor, or just to put some discredit on the image of a competitor. So obviously, if this information are reported for this reason, this protection does not apply. So that's what we need. This is why it's required to have a good faith. It means you report something because you have been made aware of a potential anti-doping rule violation, and you want this violation to be sanctioned, but that obviously that your intent is to protect clean sport and not to serve your personal interest based on potentially wrong information. So this is what will be looked at, obviously.
Okay, I think that you briefly referred to the entity, but we have a question about the International Testing Agency. So what are the difference between the International Testing Agency and WADA?
Okay, geographically, if we look at the Lausanne office, it's 100 meters, the difference. But legally speaking, WADA is the regulatory body. So WADA is the body in charge of establishing the rules, the list of prohibited substance, the code and the standards, and all what I mentioned today, and to ensure that these rules are properly implemented and applied, so to ensure that the signatories to the code have efficient and compliant anti-doping program. So that's the regulatory aspect. WADA is not conducting anything itself. It's the anti-doping rule, it's the anti-doping organization, the National Federation or National Anti-Doping Organization that are conducting testing, that are running the disciplinary process, that are running the education program. So these parts, if they don't want to do that themselves, they can delegate to someone, to a third party, to run their result management or to do their full anti-doping program. And the ITA is doing that. So it means it's an organization that is composed of many experts in the field, lawyers, and obviously I always start with lawyers, but also anti-doping experts, investigators. And for example, if FIFA wanted one day to say, okay, we don't want to do anything in-house for anti-doping, so they would go to the ITA and say, okay, run our program, and they will pay a fee to the ITA which will run their anti-doping program, but FIFA remain responsible. So ITA, if I can say that, it's an expert agency, but a service organization that run anti-doping program or part of anti-doping program for code signatories.
Good, excellent. It's 4 o'clock sharp here in Zurich, so 10 o'clock in the morning, if I'm not wrong, in Montreal. So once again, Julien, thank you very much for being with us today. It's a great pleasure. It's a great opportunity, not only for us here at FIFA, also for those who are following this activity, of course, throughout FIFA.com, on FIFA.com. So again, you can continue your activity, normal activity, Friday morning for you, Friday afternoon, evening here in Zurich. Once again, thank you very much for this great opportunity, and I wish you and your family so a very nice weekend, Julien.
Muchas gracias, merci. It was a pleasure to be with you, and I hope you got something new. You have more knowledge now, anti-doping. I hope I made it. So have a great weekend wherever you are, and good luck for these complicated times. Keep safe.
Merci beaucoup, Julien. Bon weekend. À la prochaine.
Bye-bye.
Okay, we finish here, but before closing the event, we would like to invite you to the next session of the FIFA Law Talks 2021, which will take place on the 26th February 2021. It's 3 o'clock here in Zurich, with two very good experienced professionals. So Clippo Hendel and Omar Ongaro, both the deputy chairman of the FIFA DRC. The topic, understanding Article 17 of the FIFA regulations on the status and transfer of players, exactly the same, free live stream on FIFA.com, simultaneous interpreting into Spanish and French. And that's all from our side today. So from Zurich, we wish you a very nice weekend. See you soon. Take care and stay safe. Bye.